Wait, we're live now. Oh, we are. We are the Senate Government Operations Committee, and this is it Wednesday, April 17th?
It's right.
And we are looking at H 606. We have our legislative council attorney Tim like to join us at the table.
Absolutely.
We have a updated draft with a few changes, version 1.4.
Thank you very much for having me, Chair Harding. For the record, my name is Tim Devlin, Legislative Counsel. Indeed, before you have an update to no, this is the first time you've seen this is draft 1.4 of a strike all amendment by this committee made to the underlying bill H 606 and act related to professional licensure and immigration status. The updated language has been highlighted for ease of reference and fairly minimal on paper changes, but can be described as expanding the scope of this bill. That is the application of non-consideration of immigration status when reviewing an applicant for professional licensure within the state. And it will now essentially include, or it was just those professions that were regulated by the Office of Professional Regulation. This will now include individuals in Titles 16, which would educate teaching, 20, which would encapsulate firefighters, plumbers, electricians, law enforcement officers, and then 26 was in there before, and that covers everybody that is found in 26. I should say that it's not only regulated by the Office of Professional Regulation, but also now includes medicine.
Yeah.
And the only other change we have here is in section 3, which changes the effective date to September 1st, 2024.
So I'm sorry, there's an updated version that I think Olivia passed out.
Yeah.
Or
Maybe it's under there.
There you go.
Okay, right.
So committee, as you'll recall, we got testimony from a number of different professions, and we'll hear from one final one before we vote on the bill. I did want to update you on the lawyers situation. So we got testimony from the judiciary saying that they would be happy to have lawyers included. And I asked them to send us language. Well, on further reflection and also discussion with our legislative council, they realized that actually that would not be good, because the Constitution explicitly gives the judiciary the ability to regulate the profession, the law profession. Or I should let Tim say this more than me.
The practice.
But the practice of law. And so they were like, actually, no, we don't want to be included in the bill, but they did commit to looking at their rule. What's the rule? Do you remember Rule 4? Something like that? Rule 5, whatever the rule is that governs the
oversight of this certification of lawyers. They were going to look at or licensure.
They're licensed to practice.
Licensure of lawyers.
Yeah.
They were going to do that and potentially make the same change within their rules. But separation of powers, we're not going to include lawyers. But everyone else is in here so far. Senator White.
Thank you, Madam Chair. And so if I'm understanding correctly, it's everybody but lawyers. Essentially, it's kind of the professions we're talking about that are licensed. And is it at all, and I'm happy to vote for the bill as is, but I did just want to ask, is there a way for us to get a report back from the judiciary on what they ended up doing in like a year? We can't ask for a study of any sort.
No.
I'm just gonna put it out, maybe I'll check back in on this personally in a year.
Certainly ask them
Okay.
when they testimony, we can certainly ask them in testimony, but they're exclusively allowed to license.
I'd love to know.
Yes, I think we can certainly ask them if they've done it, but
if there's, I'm careful with this.
No, I hear you.
And we've dealt with this kind of issue a lot in this committee about what we're allowed to do based on our constitution, for example. But this would include every other every other licensed or certified profession. It does include law enforcement at this point. We're gonna hear from the Vermont Criminal Justice Council in just a minute about that, so. Senator Bielanski.
So I thought I remembered in testimony that they had said we do have the power to change those rules. Did they change their minds?
Yes, they changed their mind.
Okay.
They actually consulted with our legal counsel.
Okay.
So, I think they spoke a little too soon.
Okay.
I mean, to be fair to them, I don't think they thought it through the whole way, and once they did a little bit more research and talked with a couple other people, they realized, oh, we probably shouldn't do this.
And
But it wasn't because they weren't supportive.
Yes.
It was because of the separation of powers.
okay, and would this be a place, because I know we have a joint judicial rules committee for that committee to discuss with the judiciary the progress of this?
Sure, I mean, yes, I think.
With the chair and try to
Judicial
draw.
rules, you can certainly ask them. I mean, I don't think it's gonna be immediate. I think they have to go through their process, but I certainly can
If I
ask them.
may tag on to Tanya's idea, this committee is not immune to writing letters of encouragement and recommend to a body or to whoever. And I think just given our new Americans and refugees and the people who are coming in trained as lawyers in their countries, that we would love to encourage them to figure out a pathway to licensure in this state. And I think that is what is, and we could either do that judicial rules, or we could do it as a letter from the committee, encouraging them to continue looking at this work and going down this path.
Oh,
Sure.
Well, I think it's also DACA recipients, people who grew up here, went to law school here. It's not just, new Americans and refugees, so.
So I think it's that whole universe of people, but I think a letter from us, even acknowledging we can't force them to do this, but asking them to please consider and maybe recommend in the future a pathway that could be.
Sure.
I'd help write that letter at a later date.
Well, I think we can ask our legislative council to do a draft of that letter. That would be great, Tim. And then you and I can discuss it and we can write a letter on behalf of the committee. We'll show it to the committee before we send it. Okay.
Oh, great. Okay, even better.
All right. Any other questions for Tim? All right.
So thank you.
We are gonna hear one witness and then maybe have you back up, Tim. So do you have to leave?
I am booked in House GovOps at 2 o'clock.
At 2:00.
Oh, he has 7 minutes to get down.
They're still on the floor.
They are
That's good, so
All right.
Happy to
Awesome.
hang out until.
If you can hang out, that'd be awesome. We are gonna hear from Kim McManus from the Criminal Justice Council.
Hello,
Hi. Hello.
nice to see you all in person.
Yeah, because we get to see you on Zoom a lot, but not.
I know,
here.
I know my head.
Yeah.
Yeah, so if it's weird, it's like hard to, yeah.
It's so hard. I like seeing everybody in one
Yeah.
view instead of trying to swirl around the fishbowl.
Well, and you actually get to see us from this little thing here in the middle.
Yeah.
That's what's
Yes,
broadcasted.
cruising around to those.
So you know who we all are because you haven't technically been with us just.
Technically met you, yeah, so you've done the introductions, thank you for that.
Yeah, and so you heard the discussion that we were just having, and we did include law enforcement in this. But wanted to have you in just to make sure, like the judiciary realized, oh wait, there's a problem we didn't think of. So if you wanna just introduce yourself for the record and. What do you think?
Absolutely, so for the record, my name is Kim McManus. I'm the Associate General Counsel for the Vermont Criminal Justice Council. Executive Director Simons was hoping to be on as well. She has had a morning of technical problems. Her and her computer are not friends right now.
Oh, God.
She did want to appear briefly as the broader topic of inclusivity within law enforcement is a passion project for her. So she was hoping to speak to you directly. She would like to send a letter to the committee if you are open to receiving that.
Absolutely,
you have
yeah,
time
then we
to-
can post it on our website, that'd be great.
She would appreciate that.
Yeah.
So a really important thing just to remember, and I know we're tight on time, so I won't go on long, is that law enforcement licensure certification is different than a number of other areas of professionalism in the state, in that you have to be hired by an agency first before you can come to the academy to go through basic training to become certified. So our statutes, our rules, we do not speak to citizenship status or immigration status. It's not a requirement for someone to come into the academy. We don't need proof of that. So that already exists in our world. But a person needs to be hired by an agency. So that's going to be an employer issue and an agency issue as to who they can hire, right? And at a baseline, you can only hire folks who can legally be working in the country. So someone with a permanent visa or some sort of work visa. So that's going to be an agency employment issue. If an agency, if their policies allow individuals with varying different citizenship status or immigration status, that's for them to decide. And that would not be a barrier once at the academy. That would not be a question when certifying them. It would just be, can this person pass our program successfully? So again, just currently our rules, our statutes, we are silent on this. And I do want to just say one thing. Our Council of 24 meets on a monthly basis. And so when we were asked to testify 2 days ago, we have not had a meeting on this. So we don't have an official position as far as law enforcement in general and what their steps can be. But the bottom line is that it would be an employer-employee decision first.
But including you in here
Would
is not a problem because if somebody's hired, you could then provide them certification after they've been hired, regardless of their status.
Correct, right? It's not a checkbox on our certification process. We don't ask for any proof.
And you don't ask for social security numbers, because this is just to provide an alternative to a social security number.
So we do have a number of forms where a social security number is included, but like in so many other areas, it's not necessarily required on our end. Now, again, the law enforcement agency has to do a thorough background, so they may need that, or a federal ID number. But from our end, date of birth would satisfy the paperwork on our end.
Oh, okay. Senator Yosti, did you have a question?
Yeah, got it, sir.
Oh, okay. So are you okay with us including you the way it's included, or including you broadly, not you specifically?
Yeah, as far as, it doesn't conflict with any of our current rules or statutes, so we have no issue being included. We just wanted to make sure it was very clear what the steps were, and that we're not requiring law enforcement agencies to do something other, because we do not have that power as far as who they can employ or cannot. Very good point.
All right. Well, are there any other questions for Ms. McManus?
I guess I just,
Senator
would you just be kind enough to reiterate what you said about their abilities to be hired by the local police authority? What is required to be hired?
Well, I mean, just on a
What are
big
the immigration
picture
status that's
level,
required
you need to be able to work legally in the
in the United
US.
States?
And again, I know different agencies may do that differently. You know, there's a difference between having your green card or
There's a
or
wide spectrum there.
right, you could be on parole but have a work visa. So, and I would not want to speak for any law enforcement agency, but as an employer, right, you're investing a lot of time and energy into sending someone to the police academy, and just the application process alone often takes months, and then it's a 16, 17-week program, and you're paying that person to go through the program. So if somebody was on something that looked like a temporary work visa, an agency may understandably not want to make an
Like, if
investment.
somebody who's excited to be here and new and is on permanent status of some variety would be maybe a great person.
Yeah, right, and I think as an employer, if you can legally hire someone,
High
that's
incentive,
a
right?
question for the agency to talk to their attorney and just make sure they're checking all the boxes, right? You need to be able to fill out your I-9, give that documentation to be able to be paid. So it would have to be up to the agency.
Got it.
All right, well, thank you, Ms. McManus, appreciate it.
Thank you, and I'll be back in a little bit.
Okay. So is there any further, how's the committee feeling right now? Are we ready on this one or
We're getting there. What else do we need?
Senator White?
I would just say I really appreciate all the work we've done on this bill so far, because I think it came to us with an assumption that everyone was covered, so I really appreciate that we took the time to, I think, improve this bill from what we got over on the House side, but not change the substance of it or away from the direction that they were going. And I say that because I feel that as we kind of near the end of the session, that we're gonna be changing a lot of things that the House has done. And I just want to say I really appreciate that we did change the vision of the bill. And I think that that's hopefully seen as a good gesture in the other direction as well. Just to say that
All right,
On the record?
thank you.
on the record.
All right, well, if there,
Are
we,
you ready for motion?
I think so, except for, do we need a new version then without the yellow or can we,
I can go still draft 1.4.
you can clean copy? Okay. So I would
What's, it's still draft.
entertain a motion.
I would move that we pass out favorably draft 1.4 of H 606.
All right, is there any further discussion?
Are you reporting?
No, I'm not. Senator Norris, did you want to say anything? Because I know you have concerns. I want to just give you an opportunity before we vote if you want.
Oh, no, I mean, for our earlier conversation, I'm not going to support the bill, obviously, because it includes regardless of that individual's immigration status. And it's just not something that I agree. So other than that, but I'm going to be a definite no on this bill. So.
And just to be clear, because there are lots of different immigration statuses, your specific concern is about people who may be
Undocumented individuals
undocumented.
is my specific concern, yes.
And we did get testimony that they could
There's a lot-
potentially.
A lot of talented folks out there who could be in Vermont, earning, helping Vermont out, but it's just, that's my one problem with it.
Okay, well, thank you. I just wanted to make sure you had a chance to say your piece. Any further discussion? Okay,
I would just
Senator White.
say, because I respectfully disagree with Senator Norris's opinion, I think we have a major workforce shortage where people don't have hireable nurses. They don't have hireable teachers. We are at such a workforce shortage that it is unfortunate that the status of someone being on a spectrum will impact their ability to be a part of that workforce. And I'm in a community that has a severe shortage of workers that is affecting the quality of life of our district. And I am very proud to vote for this bill. And I respectfully disagree with Senator Norris.
And if I might,
Yeah, go for
I
it.
respect her opinion. I didn't realize this was open for a debate. You asked my opinion, I gave it to you. You gave your opinion, Senator. Okay,
We're in discussion mode because there's a motion on the
That's a
table.
motion.
So that's
Just put a motion
discussion
on, so
is-
that
we're in
anybody can
discussion.
discuss.
So any
Really?
further discussion? All right, Mr. Clerk, would you like to call the roll?
Senator Mahowski,
Yes.
Senator White,
Yes.
Senator Norris, no. Senator Watson,
Yes.
Senator Clarkson,
Yes,
Chair Hardy,
Yes.
and the reporter.
Senator White, would you like to?
I would proudly report this bill.
All right. So thank you, committee. Senator, I think, and we'll get you a clean copy of it downstairs. And we're gonna move on to page 872. Which is about criminal justice council.
that's why,
I was like, wait, what?
that's why Kim said she wasn't going to.
Yes.
This is very deep.
And I don't have the right.
What, you don't need to?
872. So we did a walkthrough, thanks, Tim. We did a walkthrough already of this bill, so we're gonna start to take some testimony. And this, just to remind the committee, because we have so many bills, is related to the Criminal Justice Council and specifically the Law Enforcement Officers Code of Conduct and the enforcement of that. So H 872. And we have Lieutenant Colonel James Whitcomb. Would you like to join us up at the table? And you've been in our committee before, right? Not for a
Not
while.
this year, not this year.
Yes, last year. We're all still the same people,
Yes.
so, okay. But thank you for joining us. And you want to just introduce yourself for the record and tell us what you'd like us to know?
Sure. Good afternoon, my name's Lieutenant Colonel Jim Whitcomb, the Deputy Director of the Vermont State Police. And I'm here representing Commissioner Morrison also,
Great.
Department of Public Safety. As part of my responsibilities, I represent the Commissioner as her proxy on the Vermont Criminal Justice Council. In this role, I participate with my fellow Criminal Justice Council members in this past year's review of the Criminal Justice Council authority regarding unprofessional conduct. I'm happy to report that from our perspective, the review conducted by the council's working group was thoughtful. It was systematic in its approach, as directed. We feel that the recommendations presented to you represent changes that work to provide clarity for our members, fellow members of law enforcement. It represents simplified language and process. We feel the changes address past concerns also, and will ultimately serve to enhance public trust for law enforcement profession. Importantly, we've been able to work through changes in a way that also represented consensus among the working group, and ultimately had better understanding as a result. Happy to take some questions if you'd like.
Okay, so overall, you're supportive of the bill as it's, okay. We did, I just wanted to, do you have copies with you by any chance of the bill?
I have a copy.
Okay, so one of the things we were discussing the last time we went over, the first time we went over the bill, basically, was some of the let me see if I can get it to the right place. Oh, on page 7 and 8, the sort of list that starting, the A through H, or no, A through L. Whether or not this language was tight enough and easy enough to interpret and for not only for the council, but for law enforcement in the field and for our understanding as well, like to make sure that this list was tight enough language. So I just wondered if you have any suggestions for anything to
Not
change or
specific
anything?
suggestions.
Okay.
Yeah.
Okay.
This is B 1 through 4.
Page 7,
B,
the
the category, B 1 conduct.
4 is basically starting at the bottom of page 4.
The list there.
through
Okay, got it.
L. I just have a lot of question marks on my draft, so that was where I wanted to see if anybody, and Roger, I'm looking at you too, have any suggestions, and if you want to think about it,
Well,
then
maybe a general statement.
yeah,
This sort of was contemplated, these were derived from looking at 12 factors that are part of labor law.
okay,
So they do come from the language,
Something
may be a bit different as viewed in the bill.
okay,
But that's the nexus from where those were
Ah.
from.
okay, all right. Senator Watson?
Thank you. If I have a little specific questions about this list, in G, so the consistency of the penalty of any applicable agency payable or penalties. When we talk about consistency, is that consistency within that department or across the state?
Um,
Or does it matter? Is that too vague? That's my question.
I guess it could be interpreted both ways.
Do you want it to be interpreted both ways? Would you prefer that it be?
I think it goes to the idea that each agency has to develop their own consistent practice.
I was fine with that. I just wanted clarity, to make sure that we are understanding it correctly. And then H, so this is about, let's just zoom out for a second. This is about disciplinary action being unreasonable. And so H is based on like the notoriety of the offense
Yeah, that was.
or its impacts the reputation of the law enforcement agency, blah, blah, blah. I guess I could see that going both ways. My first read of that was to say that if there was an offense that got a lot of press and therefore deserved more of a punishment than it got, that feels like a door for not justice. Does that make sense? Like if you, like this was a big deal case, you should have had a more severe punishment. Versus, I could also hear it going the other way to say, this was a big case, this was an offense that got a lot of press, and as a result, the punishment was too much.
Yeah.
And so I'm worried, I'm just worried about notoriety in general skewing what happens.
I understand what you're saying.
Yeah.
I think that it does open a broad understanding, it can be interpreted differently. I do point to the fact that it's part of 12 factors. And it alone has to, it shouldn't be potentially that alone. And I think there may be better people to speak to labor law and reason why it's stated the way it is.
Okay.
Because I think there is precedent through labor law.
Okay, that's, well, even just that is helpful to know. And makes me wonder if through, in other channels, how that particular factor has been used. I don't know if we'll be able to find that answer, but thank you.
Yeah, I mean, just to piggyback a little bit on what Senator Watson was saying, I think the consistency question is concerning because it could be consistent within the state police, like you have your own set of standards and then, you know, Sheriff Marcoux' office might have a different set of standards and, you know, the Middlebury Police Department might have a third set of standards. And so it seems to me that an officer, any of those three would be judged based on the consistency within their own agency rather than the consistency across the state. And that's a little troubling, actually.
Speaking from the standpoint of the Vermont State Police, we're very confident that we've had process and precedent in which we hold our troopers and members accountable. I do see where it's written the consistency of the penalty with any applicable agency. Agencies, table penalties is the way I interpret that.
Mm-hmm.
I think it's important for the Vermont State Police to have set precedent and stay in general to those precedents.
Mhm.
When we're
Consistent within your
contemplating
own-
discipline.
Yeah. Okay. Senator Yoski?
Yeah, I share both of the concerns that were raised, you know, when we think about trust and uniformity, you know, I could think as a citizen, I would want to know that if a Vermont state police officer did something wrong, they're going to be held to the same standard as if a municipal police officer did something wrong. And so I appreciate, and I know the Vermont State Police has done an incredible amount of work in this area, and that sort of uniformity, I think, creates some of the trust and transparency that we're looking for. And then on the notoriety piece, I have similar concern too, just because we know there is media bias. And so if the media attaches to a certain thing, does that person then get reprimanded in a way that's not actually really fair, and I know it's one of many. It really gives me pause, just given the world that we live in, and it may be an existing labor law, and maybe it doesn't belong there either.
Yeah.
Yeah, I think maybe we can see if Damien can come and talk to us about this. He's our labor attorney. So he might have, because that is really helpful to know that that's where the council sort of pulled these from, was from labor law. So, yeah.
It's not like a statement that you think notoriety should be a major part of
No,
any of these.
it's backed by,
Yeah,
Yeah.
that's good to know.
I just think right now in the point in time we're in there is a lot of media attention and I don't wanna see that skew justice.
Yeah, it can skew one way or the other.
Exactly,
Yeah.
exactly.
Yeah. Senator Norris.
Yes, thank you. And this may be a question for Ken. Under C, where it says the law enforcement officer past disciplinary record. Is that something that we're talking about in-house, like say, like in Rogers' shop? Or does the council have access to Rogers' shop minus a subpoena, or that is something they voluntarily give over in-house? Or does the council keep records of disciplinary?
Should I?
Yeah, go ahead.
On the record for a moment. So disciplinary records are kept with the agency. If an officer has had any certification, any professional complaint violations, that is paperwork that we would keep on our end. And I'll run through sort of how we see this process playing out when I testify, but when we see this list, this is definitely thought of as agency specific. So the agency looking inward to say, how are we balancing out how we decided to discipline this officer? And did they take in the officer's discipline record? If we find out they didn't, that might be a big hey, why not? And then we might need to subpoena those records if we then were challenging them on their decision.
Okay. Any other questions for Lieutenant Colonel Whitcomb? Well, thank you so much for your time. I think we're gonna keep working on this, and if we have another round, we'll definitely have you back to comment on it before we vote on it, so.
appreciate it.
Yeah, but thanks for your time today. Chief Ron Hood, Chief. You're up on, there you are. Hey, Chief, we can't hear you. Are you?
Here I am now.
Oh, perfect, excellent. Thanks for your time today. If you've been with us before last year, correct? Yeah.
Yes,
So
once.
you want to just introduce yourself for the record and tell us what you want us to hear?
So my name is Ron Hogue. I'm the Chief of Police with the Essex Police Department, and I'm also the president of the Vermont Association of Chiefs of Police. So I'm happy to say that I don't have anything really controversial to say. The Chiefs of Police worked on this as Lieutenant Colonel Whitcomb said, in a collaborative effort with a number of groups, and we feel that the language that's in the bill as it's written is sufficient, and we're pleased with it, and we would support it the way that it is. I do have a couple of comments based on what you all were just talking about. If I could weigh into that just a little bit.
Sure.
So just taking a look at the language of that section that was just being discussed. My impression of that is that one section is for the council to be able to take a look and judge what the agency's punishment was going to be or disciplinary action was going to be, and weigh that against these things that are written in the law as to whether that should be a valid disciplinary action, and to make sure that there's not unfairness that's going on there, or there's not anything by the agency that is being hidden or somehow being covered up or taking a disciplinary action that is not sufficient for what the actual offense was. So just in that section G at the bottom, some agencies such as mine have an agency table of discipline. And I think the way that this was written was to ensure that it prevents a chief of police from ignoring that altogether and saying that they're either going to do something too harsh or even more likely something too weak against an officer who commits a certain offense. So that's basically, I believe, where that one line comes from.
Okay, is that, do agencies, is there a standard table of discipline, or does every agency make up their own?
Well, when agencies are considering policies, they always look at another agency's policies that they may already have been written. And they take things from those policies for their own. As for ours, I can't say when or where it came from. It was done back in the 2000s by the chiefs then, and the agency back then. So I don't know where that came from, but I'm sure it was something that looked consistent with what other agencies around us were currently doing for discipline. So.
Okay, is it your experience, since you're the head of the municipal, is your experience that municipalities have very different tables, or are they all fairly similar?
Well, I'm not sure exactly how many agencies have tables and how many that don't. I've worked for agencies that did not have one, and now I work for one that does have one. So I would say some do and some don't. The ones that do are somewhat consistent in what their disciplinary procedures are.
Okay, that's helpful. Senator Vigos, do you have a question?
I do have a question. Thank you for being here, Chief Hogue. These agency tables of penalties, how often are those updated? I mean, the world of policing and what's okay and what isn't okay is a rapidly evolving. And so how often are those updated to reflect where we sit now as opposed to where we sat in 2000?
Right. It depends on the agency. Obviously, they review their policies on regular timetables. For us, that's usually between 1 and 5 years. Every 1 and 5 years, we look to review our policies. So, in reviewing those, agencies will look at, like you just said, is this still consistent with what currently is going on? Is this sufficient? If it's not, then let's make a change to it.
One second. Did you have more to say? I don't want to keep
No, that was basically what I wanted to say about that section. Sure.
Okay, great. Senator Watson has a question.
Thank you. I think you may have said this. I just want to confirm. So are departments required to have a table of penalties?
No, they are not.
Okay.
Okay. But so basically what I'm hearing is that the chiefs of, and you're speaking for the organization of the chiefs of police, and you're supportive of the bill as it is, Sam.
Yes.
Okay, great. Are there any other questions for the chief? Okay, great. If you're able to hang out just in case, that would be great.
Yes, I will. Thank you.
Thank you very much. And Sheriff Markey?
Good afternoon.
Good afternoon. We know you've been here.
Yes, Roger Marcoux, representing the Vermont Sheriffs. And I've gone through this bill with Mark Anderson, Windham County Sheriff Mark Anderson, who is our representative on the Criminal Justice Council, and we support it. Just a few comments that I have is, for example, the first part of it is the code of conduct. So that goes on for, maybe 2 or 3 pages. And I think you'll find that other departments have a more robust code of conduct. Mine is like 15 pages. However, there are some departments, sheriff's departments, that probably do not have any code of conduct. So I think that this is, I have all of this in mind when we're talking, in keeping it in mind when we're talking about Act 30 and the sheriffs, trying to reform the sheriffs. So I think that this fits right into that. With respect to the section about Category B conduct, a lot of what was stricken out of here appears to have been put back into the code of conduct. So there's one observation I made. I was not involved with the committee that came up with this, so I had a first look at it last week. There's some question marks that I had just simply because I wasn't part of that group. With respect to G, in the conversations that have taken place with Chief Hogue, regarding the table of penalties, I'm not aware that the sheriffs have any tables of penalties. Perhaps that's something for us to look into, as we continue down the Act 30, just so that we have some consistency.
Yeah.
And I know that we have to look at our internal affairs capabilities and everything with the sheriffs. So it seems like that would be a good fit. You go from the investigation to the adjudication of the penalties. So, on page 9, my page 9 under I, it seems to me that under 4 through A through G, it was more related to the investigating agency. And then on I down, that looks like it's a more skewed towards labor. I don't know what clarity of notice is. That's a question mark that I had. But you know, in looking at what discipline that you're gonna have for someone, you know, is there a possibility for the officers rehabilitation, which seems like a labor oriented direction. Certainly looking at all of the circumstances surrounding the offense. And the other one that is more clear to me now, but was the adequacy and effectiveness of alternative sanctions to deter such conduct in the future. So to me, that just simply means, is there more than one penalty with the eye on maybe not so much punishment, but a rehabilitation?
Yeah, with that, like counseling or training or mentoring or something like that.
Yes. And then so basically that's what I had. You know, I was, you know, the sheriffs that responded kind of left it up to me as to how we felt and how we feel.
Well, so speaking of that, so since you said that your code of conduct is like 15 pages, and this one is relatively short, are there things that are not included in this that should be included in this code of conduct?
We're reviewing that. We review our policies. It seems like every year we have to go through because there's new things that come up or things that I missed or what have you. What I noticed about, I was going to submit this to Olivia yesterday, but what I noticed is that a lot of what's in ours speaks to, is included in other policies. So what I have to do is to see, you know, what is appropriate, what is too much, because you want, this is one of them. This is a policy that you want your employees to understand and retain.
Yeah,
As opposed to some that, I need to go and review that for this particular instance.
Right.
So I just want to make sure that this is not, mine isn't overly complicated. At the same time, we're gonna look and see if,
okay.
yeah.
That would be great, if you'd be willing to do that sort of cross-check, and let us know if you find anything that should be in here that isn't, that from your perspective. Because we definitely want to make sure it's not a code of conduct light, you know, that it's an actual useful one, but definitely hear you on, want it to be understandable and memorable, that somebody doesn't have to check the
Right.
book to make sure their code of their conduct is okay. Senator Bielski.
Yeah, thank you. I certainly appreciate the work and robustness and don't want to in any way encourage you to water your code of conduct down. And I also appreciate the desire for clarity. But similar to Senator Hardy, would love to know if there are places within your code of conduct that you think we can include that should be here. And I know that this is sort of the floor. You're welcome to have more robust policy, but I know you've done a lot of really good work.
Thank you, Senator. I think that this H 872, the code of conduct, hits all of the big marks. And you know, the thing about it is that I think that, you know, I'm pretty sure there's probably some sheriff's departments out there that don't have any code. of conduct. So, you know, at least we're getting something in the order, so.
Right, right.
I didn't see anything that was certainly unreasonable, what have you, so.
Great, thank you. Any other questions for Sheriff Marcoux?
Did have a question,
You do have a question? Okay.
but I apologize. I had an administrative task. And I don't know what I'm doing. I do so many things.
All right, Senator White.
Thank you, Sheriff Marcoux, for being here, and I really appreciate your commentary on this bill. We have another bill, actually on our wall, 585. And I don't know if we're gonna have you come back in and testify at all on it, but I do just want to note that you know, I'm as we talk about the changes that are happening with our requirements for law enforcement, I also think it's important for us to just talk about the long-term investment in that kind of workforce in general. So I did just want to point that out.
If that happens, I'm happy to come back.
Are there any other questions? So if you are able to look it over and get back to us, that'd be great.
Yeah, maybe by the end of the week, first of the week.
That'd be great. Thanks, Roger.
Thank you.
All right, Milo Grant is now back, hopefully on the right bill. Ms. Grant, are you there?
Yes, I am. Hi.
Awesome. We saw you yesterday, but now I think we're on the right bill that you were interested in testifying on. So if you want to just introduce yourself again and tell us what you'd like us to know, that'd be great.
Thank you very much. My name is Milo Grant. I currently serve on the City Council in Burlington, Vermont. I have previously served on our Police Commission, and I also served on a special committee to review policing policies back in 2019. This committee was formed after some use of force lawsuits were filed against the city, and in my opinion involved racial discrimination. We worked on that committee very hard to review training, procedures, policies. It was very important to me to have an understanding of how our officers were being advised. We came up with a new use of force policy that has been applied statewide now. But even so, the old one was still violated 6 ways to Sunday, but we do have a new and better one. During the course of my service on that committee and on the Police Commission, and now as a police counselor, you know, when I look at the code of conduct, some things came up to me. There has been, I know the state auditor had done a report, I believe in 2022, that talked about the fact that with regards to the training that officers should be receiving annually in order to maintain their certification, that records were not being kept well across the agencies in our state. There was that inconsistency, and there was not really, from what I took from it, and then also from my personal experience when I've asked for information about, say, training about racial disparities, because Burlington is becoming a very diverse community. And some of our communities have a distrust of our department, regrettably. But it was very difficult to get documents. And when I received one document in particular, it was an Excel file that was, quite frankly, embarrassing. It also, in my mind, was very outdated, where it wasn't giving any recent training within the last couple of years, especially given that we had these lawsuits that occurred. So my concern would be that there is some sort of standard that needs to be established and followed so that we know our agencies are making sure that our officers are getting the proper training, and that there is a consistent way that agencies have to be maintaining this information and reporting this information. Burlington is, I believe, the biggest agency in the state. And I think we're having some problems with that. Well, I know we're having some problems with that, and it causes me grave concern. And I think also we need to know during this time where agencies are short-staffed and there's a lot of additional pressures on our officers, that this training is important. And if we, if someone doesn't have that training by a specific time and then they're given an extension, but nobody's following up on that, that hurts someone that's in the street, because training shouldn't be a one and done. Periodically, people need to be reminded about things, especially use of force policies and procedures. We had an appeal recently that was rejected. So that's going to come back to the city to take a look at, to see what happens with that case. We had another case that was dropped this year to us against the city after resolving yet another case. So when I look at all these instances, so many issues are around training. So some training, especially with de-escalation and racial disparities, shouldn't be one and done. And I think the last thing I will say with regards to the code of conduct, there are some things that around intimidation that I don't think are really clear, because I think when you look at intimidation, that's not necessarily breaking a law, but is a problem. And so I feel that should be made more clear. There was a specific complaint that when I was on the commission, we submitted the statute we felt got closest, but wasn't an exact match, so to speak. So even though the council came back with their decision, which was strongly worded, they could not find wrongdoing because it per se, they found things were wrong, but it didn't live up to the particular statute that was referenced. So they recognized it wasn't okay, but couldn't do anything further. And so I think intimidation is unfortunately, to be real about it, an issue that we have even among the leaders in our agency. And that's something that needs to be looked at. And I think that is all I have. Thank you so much for your time and the opportunity.
Well, thank you, Ms. Grant. I think we have a couple questions. Senator Vygotsky.
Yeah, thank you for being here, Milo. If you were to include policy around intimidation, where would you put it? My initial thought is on page 3, line 3, the misuse of official position. It currently lists sexual misconduct and harassment, misuse of property and evidence, solicitation, taking and giving of bribes, use of electronic criminal records and database for personal, political, or economic gain. And then my thought would be that would be the place that into policy around intimidation would be housed. Is that where you would put it, or would you put it somewhere else?
Yes. When I was reading that area, that's what really jumped out at me. And it was something that I looked at because regrettably, we've had this issue in the city of Burlington. So, and it was it's very shocking to me. It's affected how people feel about leadership in our department, which unfortunately sometimes affects how people feel about the officers. Because if you see a leader doing that, right, and trying to intimidate people, and they're doing that in front of officers, what are our officers learning? So there's repercussions to that type of behavior.
Are there other things that you, in reading the conduct, that you think should be added, or was mostly intimidation and then standards across the state?
Right, standards. The other thing that was really important to me was the discrimination and bias enforcement, and I saw that listed. I think needs to be a better way. Multiple agencies in our state have paid out money in lawsuits due to discrimination. And I don't think we're where we need to be yet. When we look at how we grow as a state. You know, we're a state that's aging. We have a lot of youth leaving, where we need to be welcoming to all kinds of people in order to, you know, survive and grow as a state, build our property tax base, have people that can work for and support businesses, etc. But when people look different, and they can't trust that they'll be treated the same, it's demoralizing, and word about that gets around. You know, people in our community, they know certain officers, they know who the good ones are, who they can trust, who they can go to, and they know the ones that they wouldn't want coming to their door. And how do we codify that in a way that training is required in that area, training is tracked, and that there is a standardization, and that there is an enforcement of that type of training.
Okay. Great, well, thank you. Are there any other questions for Milo? All right, thank you so much, Milo, for being with us. I'm glad we got you we synced up on the right bill and the right day.
Yeah. Thank you. It's been very interesting listening to all of this. Thank you for your work.
You're welcome. You're welcome to stay and listen more if you want to.
Yes, I will. Thank you.
So last we have Kim McManus again. You want to just come join us at the table?
Thank you.
All right, go ahead and introduce yourself again, and then tell us what you'd like us to know.
I am still Kim McManus from the Vermont Criminal Justice Council.
I'm so glad nothing's changed. It's been half an hour.
I know, wouldn't we all be really concerned that I had a different name? So I had a long spiel on where we've been and where we're going, and it seems like you all don't need that. You've dived into the specifics. I think you see what we're trying to do. So I'll start off just answering a few of the points, or not answering, but chiming in on a few of the points that have already been raised. And then, of course, any questions. So an act of discrimination is a great example of why this is a wonderful move forward, right? In our existing statute, if we had an officer act in a discriminatory manner, and it was a violation of their local law enforcement policy, a complaint would come to us. We would be able, if the facts supported that, we'd be able to make a finding, and we would write a letter that went to that officer, and then nothing else would happen right now, right? The category B, first offense, discrimination is not one of the exceptions that we can take action on. With this change, right, we're presenting that we can take action on all category B offenses. With the change in the category B definition and taking away the local law enforcement policy being what we attach to. So sometimes what we've had happen, say in the discrimination case, is the policy, the way it's worded, that particular agency's policy, if it's not worded in a way that the facts can fit, like, oh, the officer had noticed that this would be a policy violation, we can't make a finding. If the policy does fit, it's happening, or the facts fit policy, we can make a finding, but the letter goes to the officer, to the agency, and that's it. Now we would be able to make a finding that would then be public, right? The public will know what decisions are being made on these category Bs. And the balancing act there, law enforcement is now essentially saying to us, okay, council, we trust you to be making wise decisions as far as sanctions go. Because we have to remember that employer discipline is different than certification sanction, right? So an employer wants to be able to work with their employee, and if they see something that they can work with, as Chief Marcoux was saying, that they don't want us to override that on a first category B offense. Understandably. So say for that discrimination example, a finding was made, the facts and circumstances, the department decided, a written warning, with additional training. Here's the training schedule that we're given. If that's the information we receive, the council would now be able to look at that. Well, first, the professional subcommittee would be able to look at that, decide whether we think there was a violation, right? So the agency can make a finding and say, oh, we took disciplinary action on this. We get it. We look at our new definition, which hopefully you all accept. We look at our code of conduct. If that all squares away, we can make a finding and say, yes, this is category B, first offense. What did the agency do? The agency had a written warning with a schedule of training. If all the facts and circumstances that feels reasonable, then we, as the council, would write to that officer, you're receiving a written warning, and that's based on your certification, right? That goes into our file. If that agency, say the event, is something, a written warning is just completely, just untenable, right? And I can't even think of an example. Well, we can take an officer publicly on the street says some horrible racist comment, right? A crowd of people hear it, it's flagrant.
They put it on Facebook.
Perfect. They post it on Facebook, everyone's upset about it, the impact on the community. That goes towards that piece about notoriety, right? What we've heard from law enforcement, what I see on the subcommittee all the time is what officers do in the public reflects on the agency. And so it does matter to agencies, and I won't speak for the folks behind me, but how this gets out, how it ripples to the community. As Ms. Grant said, people in the community know, who's who and who acts in a certain way. That impacts the agency. So that might be a factor in how the agency decides to move forward, right? What is that impact that goes out because of that officer's behavior? But the larger point and why the council supports this is that when we looked at that code of conduct, and again, we crafted that just because we knew this discussion would be impossible without having a draft of a code of conduct in front of us. We basically looked at, what are the behaviors that are not, they go beyond discipline, right? There's one thing for an officer to regularly not clock in on time, right? Like, Officer X never does his timesheet right. There's always a problem. He gets written up, he gets discipline stuff for that. That's not a certification issue. If Officer X starts lying about how he's clocking in or out, that's a certification issue, right? That's an issue that truthfulness is something that law enforcement feels strongly about. So when we built that code of conduct, for the most part, if an officer violates that code of conduct, it's more than likely that that agency is going to be looking to terminate or resign that person, not exclusively, but this is the worst of the worst behavior. That's not criminal, right? We still have an ability to hold people accountable for criminal behavior. We have category C for council policies, but this is what is the behavior outside of criminal behavior that we do not want our police officers doing. And so if an agency says, we can still work with this person, and here's why. Here's why a suspension is appropriate. Here's why a written warning is appropriate. All we want is that safety lever to make sure that that was reasonable. And so, as I mentioned a meeting ago, we put that language in at the end of our committee work. We had not gone over it with a fine tooth comb, and so we definitely want all of your eyes on it and picking that apart. But we just knew law enforcement appreciated that we want that balance, and that we wanted that balance to be able to just do a check, because we did put this change does take away our unlimited ability to act on a category B first offense that you all have pulled out, the sort of the big ones. So now we're saying these are all big, let us take action on them, but we will respect an agency's reasonable decision on the first one. And we have an override mechanism if we need it. On the second or subsequent, we get to decide what we think is appropriate. And by we, again, it's the larger 24% council in which law enforcement is represented. Wow. a few specifics within the bill that I just want to flag. The way it's worded right now, as far as the code of conduct, we appreciate that the council would need to adopt rules about how we would amend the code. What I would add, find a spot for you all. So, and this would be a question for Kim, I believe, on page 3. 2371 subsection C code contents. It says the law enforcement officer's code of conduct shall prohibit the following, and then there's a list. The council would ask that this is not considered an exclusive list. Our hope to have this code of conduct live with the council is that we are able to adjust and evolve and be responsive.
Sorry. It's actually page 2.
Yeah.
I'm sorry, do I have an old copy?
Paragraph C, code of
Yeah.
conduct.
Yes,
So you're asking that, 1 through 6
yep.
not be exclusive, that,
Say, not including, but not,
Yeah, exactly, but not limited
But
to,
not
so
limited
that
to,
the
right.
council is not restricted to only what is listed in statute. Like, we would need to include these items, but we may, because again,
Right.
we have not created this code yet. We've drafted one in committee, and it would definitely be the backbone of what we see moving forward. But our council members may want additional items, and we would not want to be restricted.
so along that, that's good to hear, along that line, in terms of what's on this list, if you look at number 4, which has been mentioned before, discrimination and bias enforcement. It says, if the lead in to C is shall prohibit the following categories of conduct.
Interesting.
And it says discrimination and bias enforcement. I'm assuming you don't want to prohibit bias enforcement.
Correct.
Yeah. So I
All
definitely,
right, that's a good
that,
catch.
is not
Right,
worded
we'll
correctly.
just make sure the
So
shall
it's-
prohibit, yes,
Uh,
well, shall prohibit. We do want to prohibit bias enforcement though.
yeah,
Oh, yeah, no,
Yeah.
it's not the enforcement of discrimination and bias policy, it is just,
Bias enforcement,
it is prohibiting of discrimination, bias,
correct.
law
Bias.
enforcement.
biased enforcement. Okay,
Yes.
that's-
biased enforcement.
Yes, so
Oh,
we do
yeah.
want to prohibit that.
We do want to prohibit it, but that wording is, I had, until you said it, I've read it like 16 times and I'm like, why would you want to prohibit?
Yes, it's
The-
not
Okay,
discrimination and bias enforcement, it's discrimination and biased enforcement.
yeah, okay, but it's not worded great.
It's not.
The, okay, maybe. in-
Other thing, and I wonder, going back to see if the way, so one, I heard multiple times today that Ledge Council is no longer using the language of including but not limited to.
Yeah,
But, and it would be weird hearing it, so I wonder if it read the law enforcement officers code of conduct shall prohibit at least the following categories of conduct.
yeah, we can ask Tim how
Okay,
to
how
best
to do it.
draft it, but I wrote down, as you said, just to, as a flag for talking to council about it. And does this, when does the council, okay, they by December 31st of 2024. I am wondering if the committee, I think having a report back to us on it, like presentation, if nothing else, would be great. If you're doing it on by December 24, having some kind of reporting back to the legislature on what you came up with would be great. Even if it's just in testimony, so, I'm assuming you're okay with that. I mean,
Yeah.
it doesn't have to be a formal written report, but just a presentation too.
We will be
I'm
very
glad to see
happy.
that.
If
Okay.
this proceeds forward, we will be delighted to show you our.
Yeah. Thank you.
You have to get a
And what do you think about adding the point about intimidation that was suggested by Ms. Grant?
I think. I mean, first glance, I don't think there's an issue with adding it. I think we as a council would just need to talk through again that wording, you know, and again, I understood what Ms. Grant was speaking to, and we spoke about it at the committee. Again, that idea of, because you're a law enforcement officer, you do have to be mindful of your presence and how you're interacting. But what is that, where's that line from, you know, needing to be controlling a situation, and then you cross into intimidation? I think we just would be really mindful of that wording. I think we all know what we're talking about, and it's sort of you know it when you see it. And I can say, just to back up, Ms. Grant's example is another great example of the policy did not align with the facts, and so a finding could not be made. And that is the problem with relying on local law enforcement policies. And Senator, that you said earlier, right, we don't want these to become less uniform. We're looking for more uniformity. And again, that's what we hope with this, not hope, we believe with this bill, by getting away from how one law enforcement agency writes policy and another, having the central code provides us that consistency, and being able to take action on every category B, having those be public, creates accountability and uniformity, because then there's this volume of information, not just for the public, but for law enforcement agencies to see, you know, what behavior has what outcome.
And one second, so to that consistency, that's conversation we just had about G on page 8. Consistency with the penalty of any applicable agency table penalties. If agency tables are completely all over the map or non-existent, how can you even apply this?
Right, so a few things in this section to speak to. One is the subsection 4, the overriding statement before the letters, is that these are factors to be considered. And the Labor Relations Board has case law that speaks to, you don't have to consider every factor gets the same weight, but essentially giving you, what would you look towards for unreasonableness? So if we thought an agency made an unreasonable decision, and we said, wait a minute, we can't be limited by this. We would then look towards these factors to see, like, why is this unreasonable? And we'd be going through these factors, and again, not everyone would apply. So if an agency did not have a table of penalties for us to say, you know, could you show us how this fits or doesn't fit? Then the line above it would, okay, have you had officers similarly situated in this situation? You know, have you had how many discrimination complaints have you had? What were those outcomes? We could ask you that.
So
to get that sort of, what is an agency doing?
So if it was, for example, a sheriff's department that did not have a table of penalties, you could look at what maybe Sheriff Marcoux's department did, because they do have one, and that would be similarly situated, because they would be both for the sheriff's department, or?
Well, I believe when we adopted this, the language we looked at as that agency is making this decision, what's their consistency within their agency.
Okay.
So, you know, and it could be that, you know, an agency never had a situation come up, whatever it might be. And maybe if that sheriff does reach out to the sheriff's association, like, hey, I want to keep this person and here's why. You know, what do you think? Like, is this reasonable, or am I, you know, out of my depth? Then there might be a point, but those two factors may not be ones that we can look towards as a council as a reason to override. But I think when you look at all of the factors together, depending on the situation and depending why we would want to override that decision, there's usually one or two that are going to stand out. You know, we think an officer, the situation is that an officer lied in an affidavit, right? So they're like, yep, definitely lied. The agency says that, sends it to our way, but they say, you know what? We think it's a written warning, and the reasoning is the person's never done it before. Well, that may or may not be a good reason. It might be a great reason, you know, the person 6 months out of the academy made a mistake, you know, said this, but, you know, didn't realize, you know, it came out this way, or, you know, something like there's gonna be within those facts and circumstances, like, there's gonna be a reason why the professional regulation committee feels dissatisfied with an agency's decision, and then it would be our burden to look at these factors and to be able, because what I would need to do is argue this, right? I'd have to first get over this hurdle to be able to take an additional sanction. So it would be my argument to the council, here's why this was unreasonable. And it might be 2 of these factors, it might be 6 of these factors.
Okay. Senator Yoski.
My question is somewhat pretty in line with Chair Hardy's question, and that is, so if we're gonna say we want a uniform code of conduct, why would we not also have a uniform code, like way that we respond to violations of that code of conduct? Because sure, we can look at the consistency within that agency, and maybe that agency consistently under or over punishes a certain person, or so I guess I'm really confused why we wouldn't say, here's the universal code of conduct and here's the universal response to violations of that code of conduct.
Well, because again, we get into 2 different lanes. There's the employer's disciplinary action, and then there's our certification action. So I mean, I suppose the legislature could request that law enforcement have a uniform table, I suppose. I'm not quite sure how that would all play out, and I don't feel like I could speak to that as an agency. Like, I think agencies would need to weigh in on that, and I hear what you're saying, and I think so. In the scenario, an agency's we always give a written warning for category B1 when it involves misuse of position. Say like that. Now, again, that's one factor. If the misuse of position is, you know, somebody, was intimidating someone to give them money. Hey, don't come, I won't go in and bust you, so you'll pay me off, right? Like, that's a misuse.
A lot under SVU.
Yeah,
Like,
so
okay.
aside from the criminal conduct that might be there, if say that there wasn't a criminal case,
Yeah.
right? And the department's like, yep, written warning, because it's the first one. Wait a minute, like, we're gonna say, look at the severity of the situation. Look at the impact that it's had on your organization. Not just your organization, look at the impact it's had on law enforcement. You have an officer who seriously, like, gets ripped from the headlines of SUV or some TV show, like, written warning, like, that's when we're gonna say that's unreasonable. So even if that's like their consistent thing, that's not going for essentially, so the council becomes the balancer to see more consistent outcomes. And again, as far as the certification goes.
Right, so I think that distinction is important at the employment versus certification distinction. And I mean, I agree with Senator Yoski, like, what we want is consistency as much as possible. And how that interacts with somebody's rights as an employee and somebody's duties as an employer, I think is something we need to sort of tease out a little bit more. So I think we will talk with our attorney who specializes in labor law and see if he can help us out. But I'm wondering if you have ideas
for other witnesses that might be helpful in talking specifically to that, because it does, just looking at it, my reaction is exactly the same as yours, like, oh my gosh, this should just be consistent across the board. If you're a law enforcement in Vermont, you should just be treated the same regardless of where you work. But that you are an employee, that you are working is an important component of it, as an employee. So, that I feel like we need to get a better handle on.
Right, because you get into if you're, you have a union.
Exactly,
Yeah,
exactly.
union,
There's a lot of issues there.
Right.
So
you
what
can't-
about this, so we'll continue, and if you have more thoughts that might be helpful, or witnesses, let us know. What about just, maybe you answered this and I missed it, but on page 8, Sharon Marcoux question about the clarity of notice, what does that mean?
So this goes towards, you can only hold people accountable for what they know about, right? So, this, and again, this is a great example actually of one that, may or may not need to be a factor in there, since the idea is we have a code of conduct, you'd be sending this to all officers, you need to sign this, that you have clarity of notice, your own notice for what would be a violation of this code. So again, this was pulled from labor relations in the instances of, if you're violating a policy or a rule of your agency, did you even know about it? When was the last training on it? When did you sign that policy? Did the policy change and you weren't notified of it? And you get into clarity of notice issues.
Okay.
So we'd
I
be
wonder if we
taking
could
that
just
out
say
of that.
something more about like clarity of notice to the officer, okay.
I could probably need to run through with Dave again on the labor law section.
Yeah.
We don't
Okay.
do labor law as a general rule.
Understandable.
All right, but that's helpful.
But it even seems like you weren't made aware of your violation even is also hard. Because you may think, like, I hate to say it, but there are situations where you as a manager may believe that you've communicated that you feel something inappropriate has happened. And then the person says, I don't remember or understand that was a violation. So it seems like that's also to give some credence to situations like that, when someone says, I didn't even know I thought you were just kind of, saying something to me and it wasn't in my record. So.
Yeah, and to that point, right, that might be a mitigating circumstance for an officer in an agency. Again, the agency, we have situations where an agency will say, we know this happened, and then the officer didn't perform well, but we really take that as our training issue. Like we see a gap and we're gonna take responsibility for this, like either because the officer didn't know or was told something different or something to that effect. But I think that language could be cleaned up a little bit. Absolutely. And let me just see if I have
anything else.
Oh, and then this would be a question either for Tim or for your forget who you said your labor.
Or no,
Damien. So again, when we pulled this language, we pulled it directly from labor relations and we use the clearly unreasonable as a standard. And without really delving into like, is that too high a barrier for the council to be able to prove that? Should it be clearly unreasonable or unreasonable, or is there another, like what again, because we want this to be a balancing act. I would just ask for Ledge Council to take a little look at that and give you all feedback, whether that is a good hurdle to get over a good standard.
Okay, and similarly, just above that on line 15, valid. And a valid investigation, what can you talk a little bit more about that?
Yeah, we actually, in our governing statute right now, we have valid investigations findings.
In 2408, is that the definition?
Oh, yeah, pursuant to section 2408.
It is in there, okay.
Yeah, and that's a pretty robust section of the statute.
Okay,
Oh, so there's an example.
all right.
Okay, great.
Any
Any other things that you've been really helpful?
Thanks. That is it. I mean, again, the big opening speech, but I'll forget that. Because I don't think you all need to.
Closing arguments? Any other, I just want to check back with our other witnesses, anything, given the conversation, since you went first, you have anything you want to say?
Lieutenant Colonel Jim Whitcomb again. So I appreciate the information that you passed on, Kim. I think one of the points I would like to make is that the committee that went through the language spent considerable time. Is it 15 to 14 to 15 meetings? And the wording was gone through with a fine tooth comb.
Yeah.
For reasons discussed. Any word that isn't hit right makes a big impact. So and then I also point to the 12 factors again. Those are the factors that are reviewed for the state police when discipline is enacted from a labor law standpoint. So that concept is steeped in labor law. And
Yeah.
I think you get that, but it's important because it speaks to consistency for us and our code of conduct. So there's history there.
Senator Washington.
When you say that it's steeped in labor law, do you mean as it pertains just to law enforcement or across disciplinary?
I assume it's across disciplines.
Okay.
If you're a state employee, these are the factors that are going to be looked at if discipline's imposed by the agency you work for.
Thank you.
Okay. That's helpful. We can get more testimony on that just for our own comfort level. And I wonder, specific to Sheriff Marcoux and Chief Hogue, what the conversation about the disciplinary tables and the conversation about an agency's own code of conduct. And it sounds like from both of your testimony, not everybody has a code of conduct and not everybody has a discipline table. Would you object to us requiring that agencies have those? I'll start with Roger since it. And then
Go ahead, Sheriff.
Go ahead, Sheriff.
So, Kim brought up a good point about collective bargaining. Somehow that, which is not gonna affect sheriffs
Right.
at all. So we have what's called progressive discipline. And so I understand the concept, but I would have to talk to everybody to see how they felt, because it's only gonna be good if they've got a robust internal investigations capability. And then if they follow whatever we come up with, they follow the table.
Policy is only good as good as it's implemented and enforced. How is that on? I know that the big list of policies that you and the department came up with after Act 30, is that on?
No, to be truthful with you, before I read this, I had not heard about a table of discipline.
Interesting. Okay.
So I'm interested by it.
If you could check, if you could check back with the association about those two things, that would be helpful.
And Senator, you asked me to compare my code. I've got an appointment that's gonna take me out of commission here tomorrow and Friday, so probably be mid next week. But
Yeah, that's fine. We're not gonna get back to the bill till next week. We have a lot of bills on our table, our wall. So yeah, that's fine. Whenever you can get to it, that would be helpful.
Thank you.
And if you can check in with your colleagues on the association about that question, that'd be great. And for state police, you already have them, so it's not.
There is recommended range of discipline.
Yeah, so it's moved for you. I mean, it's good that you have them. And what about Chief? What would you say?
Yeah, so I think there's good things and bad things about, or at least questions about requiring a table. First, I think it brings consistency to the agency to have one, and I do support our having one, because when we do discipline employees, we have that to rely on, that we're being consistent with each employee within our own house. I think the questions of that would have to be answered are, how does that respect local control for because in many cases, there may be select boards or city councils that actually impose discipline, and a chief of police can only recommend. So there would have to be some kind of recognition of that also, and just being cautious about taking control away from local governments that are really affected by what goes on in their communities.
And what about the code of conduct?
The code of conduct, I feel like it covers pretty much everything. I was just, as y'all were talking, I was kind of going through our code and just checking off in my mind as to what's covered, and everything that we have is currently in there. I believe our codes of conduct, at least I know I was asked to provide those for the committee. So they were, I wouldn't say they're models, but certainly the things that are in the code of conduct are consistent with what most agencies would already have, if
Oh,
they
great.
do have a code of conduct.
Did you submit it to Olivia so that we can look at it?
I did not. I'd be glad to do that if that's what you would like. So
If you're willing to, I would just end your discipline table, just so we have a sense of what it looks like, and Sheriff Marcoux, if you would too. Your code is really long, so.
Well, the code's not a problem.
Okay,
I don't have a discipline table.
right, okay, I hadn't heard of it.
Well, hey.
Perfect. Okay, the code would be great, just so we have an idea of what they look like, from a local perspective. All right, well, this has been really helpful, all of you. I appreciate it. We'll definitely get back to the bill, probably not till next week.